Chapter 4, the court system. Okay, you've noticed that we have moved from Chapter 1, we have skipped Chapter 2 and 3. We're going to Chapter 4. This is so, for you to write your courtroom experience paper, you have the knowledge base that you need to be able to do so. We will backtrack to Chapters 2 and 3 once we finish the courts. Does that make sense? So that's why we're jumping ahead, because it does no good for me to send you to court and have you just sit there and not understand a thing that you're seeing. So we're going to cover all of that first so that you understand what it is you're seeing, and then we'll backtrack to the other stuff. Yeah. Cool, right? All right, so the court system. You ready? Maybe I'm not. Oh, I see why. I need that. Let me try this again. Are you ready now? I think I am. Are you ready? There we go. The American court system. All right. The American court system and the structure of American courts. American court system and the structure of American courts. We have a dual court system. What does the word dual mean? Two, yes, not pistols at 20 paces. It means two. Dual, two. A dual court system. So what are the two court systems we're going to be talking about?
Federal and state.
Federal and state, very good. Federal courts, state courts. They are separate and distinct one from another. The state courts don't have anything to do with the federal court system. The federal court system has nothing to do with the state court system. Think of an apple and an orange, okay? The next thing we want to talk about is jurisdiction. Jurisdiction. We'll define jurisdiction as the authority of a court to hear and decide cases. The authority of a court to hear and decide cases. Now your textbook, many textbooks, talk about a lot of different jurisdictions. And I find that it can be very confusing for students because a lot of these jurisdictions, they overlap. And they're not very clearly delineated, and so people get confused. Therefore, I am only going to hold you accountable for just two jurisdictions, the two main ones, all right? The two main ones, the two most important ones for you to know to be successful in a criminal justice class. The first is called original jurisdiction. Original jurisdiction refers to the court that hears the original case, typically the trial courts. A court that hears the original case in the manner of trial. You are all very familiar with courts of original jurisdiction, or what we'll call trial courts of original jurisdiction, because this is what is shown on TV. If you watch any court show, any police show, any of that stuff, what you see going on in the courtroom is in a trial court of original jurisdiction. This is where the show is. You got the judge, you got the jury, you got the prosecutor, you got the defense attorney, you got the accused person, you got all the drama and the theatrics. Well, maybe not quite that much in real court, but on TV. So you're familiar already with courts of original jurisdiction. When you think of court, that's what you're thinking of right there. That's where the trial is. This is the only place trials occur, okay? This is the only place trials occur. So now I'm going to move you to the other kind of jurisdiction I would like you to know. This is called appellate or appeals jurisdiction. Appellate or appeals. We will be using both of those terms interchangeably, so please know both of them. Appellate or appeals jurisdiction refers to a court that reviews a case for errors of law on appeal. An appeals court does not have a trial. Trials are only held in the trial court of original jurisdiction. Appeals or appellate courts review cases for errors of law on appeal. You will not see these on TV because all you would see is a bunch of judges going over legal documents and papers and discussing the potential or possible error of law. And it would be like, right, so they don't make TV shows and movies about appeals courts. All the stuff you see on TV is the trial court of original jurisdiction. Does that make sense? Okay, so you know what that looks like. You got that in your head. Original jurisdiction, appellate jurisdiction. We good? We have a three-tiered court system. Three-tiered court system. Who can tell me what a tier means? Tier. A what? A tier. Okay. A level, yeah. 3 levels, 3 tiers. I like to show it with the layer cake because it actually, that's a very good depiction of the 3 tiers of our court system. We've got the lowest and the largest tier, then we've got the intermediate tier, and then we've got the upper tier. So the lowest and the largest tier refers to our trial courts of original jurisdiction. The courts that you know, the kind of court that you will go to when you go to do your courtroom experience assignment. We'll be talking about that in detail next week. Trial courts of original jurisdiction, down here. The lowest, but also the biggest and the busiest. Then we get to the center section. We see appeals courts, otherwise known as appellate. Appeals, appellate, appellate appeals. And then we have Supreme Courts. Right up there at the top, that would be the Supreme Courts. Both state courts and federal courts have those 3 tiers. So, trial courts of original jurisdiction, appeals courts, Supreme Courts, just like the cake. I hope I'm not making anybody hungry. You had lunch already, right? You have this in your course pack handouts, and this is a much nicer looking cake, a very fancy one, probably expensive. And we see the trial courts, the lowest and the largest level. We see the appeals courts in the center level, and we see the Supreme Court on top.